Why decide to look at motoring stories other than the obvious fact that we get so many of them sent to us, Wendy?
Okay, so I do receive a lot of complaints about motoring deals that have gone horribly wrong. And unfortunately, too many dealers seem to think that the CPA doesn't apply to them somehow, but it does, of course. And so the question is, if you feel that you've been wronged with a car story, and the dealership and or the manufacturer, but usually it's the dealership, especially when it comes to second-hand cars, they're not budging. The big question is, how exactly do you go about getting justice? What are the practical steps? We know that there is fantastic protection in the Consumer Protection Act, but bringing that to life and making it work for you when you're in that situation is not always
to actually invoke
easy.
It. Yeah. So, I mean, there are a few options here. I mean, as we mentioned before, you have the various provincial consumer protection officers to turn to. You have the National Consumer Goods and Services Ombud, meant to offer free mediation of disputes. But as you've said many times before, Wendy, the problem is that they don't have a lot of power to force an outcome. They can mediate, they can make recommendations, they can advise, but they can't force somebody to take any particular step, can they?
And they can't even force them to engage with them. If they don't respond, the case gets closed. So then there's the National Consumer Commission, which, by the way, does mandate these ombuds officers as alternative dispute resolution forums. They refer cases because the commission itself doesn't have any judicial powers. So they then refer cases to the ultimate consumer court, which is better known as the National Consumer Tribunal. They have the ability to impose fines, to punish, in other words, and their findings have the same weight in law as that of a court of law. So it's a very serious matter. It is, it's the ultimate platform. But getting there is a long road for many, or most.
Yes.
I think it's fair to say.
So that's if you end up at the National Consumer Tribunal and they say the resolution is that the company must make good in the following way, the company has got to follow on that order as if it had been ruled in a court of law.
Yes, but even then, some of them don't, especially motor dealerships.
Okay. So it's the latest stats coming out of the National Consumer Tribunal that have really piqued our interest in this topic this week. When do you give us the overview of what they show?
Okay. Of the 31 key cases that were heard by the Consumer Tribunal in the past 14 months, 21 had to do with defective cars.
So 2 out of 3 were motor
that doesn't
related.
surprise me at all. And of course, the unscrupulous car dealers who refused to take any responsibility for those dud cars. 7 of those claims were dismissed because they had expired due to prescription, more than 3 years old. And that is an issue we're going to talk about a bit more later. In 6 cases, the tribunal imposed stiff fines against the offending supplier, and 4 of them were second-hand car dealers.
So 2 new, 4 second-hand.
Yeah.
Okay. So later on, we're going to speak to a woman who's literally just won a car-related case at the tribunal a couple of weeks ago. But before that, we have another guest we'd like to bring in, Wendy.
Cape Town-based consumer attorney Trudie Broekmann. It was Trudie who did the analysis that we've just shared now. And
we've got her with us on the line. Trudie, it's always lovely to have you on the show. Thanks for your time again. Welcome.
Does the tribunal offer meaningful recourse for consumers who've been wronged, especially when it comes to cars? When I say meaningful, I mean, number one, that it's fairly accessible, that they can get to that forum, that ultimate forum, and 2, that there are fines imposed and refunds ordered, and that they actually do, as a result of that, get paid. In other words, do people get their recourse in the end, and how easy is that process for them?
Wendy, huge questions.
I know.
In terms of accessibility, there are issues. So it's quite hard to get to the National Consumer Tribunal for various reasons. Number one, you first need to go to the Ombud, as Wendy or Pippa pointed out earlier, and that's a sort of a delaying factor. You can't necessarily rely on the accurateness of whatever finding is made by the Ombud. I've often seen across my desk findings that are just completely opposite to what the Consumer Protection Act actually says.
Gosh.
So you can go to the Ombud and, maybe sometimes it works, but you need to do it in order to progress your case to the tribunal. Then after the Ombud, you need to go to the National Consumer Commission. And they are not one of our most well-operating government bodies.
Put.
And in the time of ESCOM, I think that says a lot. So, honestly, it sometimes feels like you are chucking your case into a black hole by referring it to the National Consumer Commission. They have improved over the years. Initially, right in the beginning, they were great. Then the black hole situation started happening. And in recent cases, I've had one or two cases where the Commission really has proactively engaged with the issue and then referred the matter to the Tribunal. But in 90% of the cases where I've dealt with the Commission, you have to intervene yourself and ask them for a notice of non-referral. Otherwise, your case never gets to the National Consumer Tribunal. And even if it does, you might lose it because the Commission's attorneys and advocates are not the best. So not always very well prepared, not always with realistic expectations, not expert at litigation, and I'm speaking from having attended hearings myself. So I'm sorry to make such strong statements on the air, but I'm most concerned about consumers' rights and that they aren't properly being looked after. Because secondly, just to answer the second point of your query,
Complicated
Wendy.
question, yes.
Yes. Once you get to the Tribunal as a consumer, if you have a decent case, you will get your redress and you get a nice, strong ruling in your favor. Once you've got it, you can enforce it using the sheriff of the quarter. You will get paid. It's once you have managed to strong arm your way before the Tribunal. My instinct is that the rulings coming out of the Tribunal are solid, are sound, and that there is a passion to provide proper consumer redress to anyone with a claim which is meritorious. And these fines, I think, speak to the, I suppose, maybe in just informal terms, the irritation of the Tribunal with all of these dealerships that Wendy experiences, that I experience, that they seem to think that they're completely above the law. I had an attorney acting for a dealership tell me that his client would rather close the dealership than pay my client out for the defective car.
That doesn't surprise me. I know that attitude. Yeah. So what sort of fines are we talking about then? And presumably they're on top of whatever recourse the consumer gets awarded, because the fine doesn't go to the consumer. The fine goes to the Department of Trade and Industry, right?
That's right. The fines are between 50,000. There are a few of 60,000 and then a few of 100,000. So the scale is between 50 and 100,000 for consumer cases and in the context of motor vehicles. But the Tribunal hasn't hesitated from properly bearing its teeth. It imposed a 250,000 rand fine in the context of the National Credit Act recently. So one mustn't assume that 100,000 rand is the worst that it can get for a dealership. If there's a particularly recalcitrant dealership, one might see even higher fine.
Okay, that's good to know. Now, Trudie, in terms of the kinds of cases that if you manage to get them to the Tribunal, you're likely to get some redress. I know there is quite an important phrase that applies here, that you should be taking a case involving a car that had a substantial defect. Do you want to maybe just explain to us about the discrepancy here, that this is a place to go if there is something that is dangerously wrong with your car, not if the color of the paint doesn't match up between the left-hand door and the right-hand door? Am I right in thinking that?
Yes, that's right. Major distinction here, and it's not that if your defect is cosmetic or more minor that you don't have a remedy in terms of the Consumer Protection Act, but your remedy will be of a different nature. So if you have a substantial defect, you have the right to return the vehicle if that substantial defect raises its ugly head within the first 6 months of you having the vehicle. or if you've had it repaired and within 3 months after the repair there's another defect or the same defect comes up again, then you can take the car back to the dealership and you can either get a replacement or a refund, or the dealership is entitled to repair the vehicle at their expense. And then once they've repaired once, and a defect arises again within 3 months, then they can't repair a second time and they must simply pay you out your money or give you a replacement vehicle. I suppose that would probably apply if you purchased a new one, then you can get the same thing. How do we know whether it's a substantial defect which allows you to get your money back? Well, it would be something like a defective gearbox, which I see very often, or engine trouble that causes the car to break down completely, a blown gasket, a serious oil leak, where we see poor prior accident repairs, so shabby repairs previously combined with a variety of smaller faults, so that the repair cost sits at over 100,000 rand. Those are examples from the cases of the type of substantial defects that entitles you to take the car back and get your money back.
What about if you've got a minor defect? I mean, you've said that you do have recourse to have it set right, but not through the National Consumer Tribunal. Trudie, just for clarity, what should you do if it's a case of there's an irritating rattle or something is not quite lining up properly?
Exactly. Then I would recommend you can take it to MIOSA if you want to, the Motor Industry Ombud, and see whether you have joy. Your claim will be just for a repair of whatever is faulty. And unless the particular flaw was pointed out to you before you bought the vehicle. So in the unlikely event that the marketing person pointed out to you that, the coloring didn't match, or that the electronics were faulty or whatever, that the aircon doesn't work, you wouldn't be able to claim for that. But if you didn't know about it and it arises within 3 years of purchasing the vehicle, then you can claim a refund of the repair costs, and I would recommend that you have it repaired yourself and get the refund from the dealership, or at least negotiate that they pay because if they do the repairs, you often, sometimes some of my clients say that they were told that it was repaired by the dealership from whom they bought, and then the repairs were actually never done. Mm-hmm. In other cases, the repairs were done in such a cheap and nasty way that actually you should have rather done it yourself and gotten the money back.
On the point, Trudie, about these second-hand cars, I've done a lot of shows and columns on this issue, and because, well, let's just talk about the National Consumer Tribunal case against We Buy Cars of August 2021. It was an Audi bought by an Anand Singh. It already had 172,000 kilometers on the clock, and he went on to do another 4,000 in 2 months after purchase. The water pump then needed replacing, and he wanted We Buy Cars to take the car back and refund him. But the tribunal sided with We Buy Cars, and the company is calling this case the leading case on the application of the CPA's right of return, Section 56. And it said that the tribunal said it hadn't been provided with evidence indicating that the faulty water pump rendered the vehicle defective, as opposed to being the result of, keywords, normal wear and tear to be expected of a vehicle of this nature. And so We Buy Cars now uses that to justify limiting its responsibility for things that go wrong on cars that they sell within the CPA's 6-month warranty period. And they say, to speak to what you've just said about problems being pointed out in advance, the CPA says the warranty does not apply if the consumer has been expressly informed that the particular goods were offered in a specific condition. In other words, it's quite an old used car. And they say this doesn't mean that every single defect needs to be pointed out. Ideally, it should be, but it doesn't have to be. And the National Consumer Tribunal did not say it's the only way to comply. What do you make of that argument, Trudie? Because it does increase the risk for consumers quite substantially. Those are buying
I agree, Wendy. Cars. Yeah. I am disappointed that this is described as being the leading case. It's a bit of an outlier, actually, if you read all the cases. The reason that I say that is that once a year I sit and read all the cases.
Yeah, oh God.
Someone's got to do it. Yes.
Tribunal, just to get myself up to speed again. And and in the context of reading all of it, you get a bit of a picture of exactly what the trends are and how a broader picture. And actually, the Singh case is not it's an outlier to my mind. The majority of the cases are ones where the consumer proves their case, the supplier is ordered to refund them, and sometimes a fine is imposed. Vast majority compared to the Singh case.
Okay, good to know.
I very much disagree with We Buy Cars when they say that Section 56.6, which says that when you selling a vehicle which has a defect in it, and you can get off the hook for the defect by disclosing it, that you use the expression expressly informed, and that's exactly what the Act says. So expressly means that you must say what the defect is. So it's no good saying what a lot of dealerships do is to say that this vehicle has got a lot of mileage and that, the ordinary types of issues for an older car can be expected. No, that's not expressly informing a consumer. You have to say the tread on the tires is very little, and the tires will need to be replaced within the next 500 kilometers or so. The gearbox has had repairs on it twice, and it continues to have niggles. Et cetera, et cetera. That's expressly informing. So if you, for example, did all of that express informing of a consumer prior to purchase, for example, Mrs. Singh in this situation, then you would have been off the hook for the tires and for the gearbox, but for nothing else. If there is then a problem with the water pump, then you would still be on the hook for it because the consumer wasn't expressly informed. And that is the only way in which suppliers are able to sell older or second-hand or damaged seconds goods which are not perfect.
Like any other second-hand goods. Yeah, that's well explained. Thank you, Trudie.
Okay. The one thing that Wendy mentioned early on that we haven't really addressed is the question of cases taking so long to get there that they've prescribed by the time they are finally heard. Is that a fairly common occurrence? Is this a big problem that it takes so long to work your way through those levels of the ombud, etc., before you get to the tribunal, that it's too late when you eventually do?
It's a new problem. So previously the tribunal used to regard the time during which your case is being investigated by the ombud and then by the tribunal, by the commission subsequently, as having interrupted prescription. So your case can't prescribe while that happens. You just need to, the 3-year period is extended by the investigation periods. Recently, in August last year, it changed its mind, and a tribunal is entitled to do that. Their rulings don't create a precedent like the High Court judges or the magistrates court judges do. They can form a different opinion from time to time, but they now regard themselves as bound by a High Court judgment, and their approach has changed. So even though your case is still with the commission, when the 3-year period from the time that the case that you realize that you have a case against the dealership, then your claim is regarded as having prescribed by the tribunal. And 7 of the 31 cases that I read, when I sat and read through all of them a little bit earlier this year, were dismissed because they were found to have prescribed. To me, that is just heartbreaking.
It's very high percentage.
Yeah, that's...
So it's a bit of a curveball for consumers because the approach is so different. Up to August last year, you could just sit back, relax while the Consumer Commission slowly works through its processes, and if it takes 4 years, then it takes 4 years, which is sometimes the case, and even longer. But all of that has now changed, and I'm quite concerned that consumers haven't been informed of this. What the solution is for a consumer is that you need to, if your matter is with the National Consumer Commission and you're approaching the 3-year period, the 3-year deadline from the time that you realize, I have a claim against the supplier, I'd better do something about it, then you need to approach the Commission and get a notice of non-referral very urgently, and then speak to a consumer lawyer to self-refer your case to the tribunal. If you're quite a savvy consumer, you can also try to refer to the tribunal yourself. All of their forms and their rules are on their website. But if you get stuck halfway through, pick up the phone and speak to a consumer lawyer to just get a little bit of intel and help as you go along, even if you want to self-refer.
Thank you for that.
Can I ask you, Trudie, when does the clock on that 3 years start running? From what marks the beginning of that process?
It's a bit contentious. So what happens is that with normal prescription, we have a Prescription Act, and that sets out in quite a lot of detail exactly how prescription is supposed to be calculated. With the Consumer Protection Act, we have Section 116, just one little sentence that deals with prescription, and it doesn't go into all of the detail and complexity that the Prescription Act does. So we're a little bit in the dark as to whether it's possible for there to be an interruption of prescription, because Section 116 doesn't speak about it, but I think there probably can be. What it says is that your case, you can no longer refer your case either to the court or to the tribunal 3 years after one of two things has happened. Either, number one, when you realize that you have a case, in other words, when 3 years after the cause of action arose. Sorry about the legalese.
Okay.
Secondly, if there's an ongoing conduct, where there's a case of ongoing conduct by the supplier. In other words, for example, if you have a supplier who consistently refuses to take back your car, even though you brought it back within the first 6 months with a substantive defect, then only once the conduct ends does the 3-year period start running. So to my mind, in 90% of the cases that come before the tribunal, we're dealing with a supplier who has an ongoing conduct.
So you could argue that it hasn't prescribed because
then
of
it hasn't.
that.
Yes.
Okay, because I did run this past Trevor Bailey, who's the executive chairperson of the National Consumer Tribunal, and he said he laid out what laws apply, National Credit Act, Consumer Protection Act, and then he mentioned that South Gauteng High Court case that you mentioned, the judgment being handed down on the 20th of June in 2020. And actually, that's not the case you mentioned. Anyway, he said ultimately the tribunal must allow its rulings to speak for themselves. We must judge each case on its merits, so it's incumbent on both parties to place their arguments concerning prescription before the tribunal to enable us to consider them and decide whether the matter has prescribed. So there is an opportunity there for you to argue against prescription. But as you say, 7 out of 31 and
it's a quite high figure.
I think that's an issue I must get my teeth into properly.
That's a good one for a follow-up. Okay.
Yeah.
Trudie, before we let you go, one last quick question. 2 or 3 people asking the same question on the WhatsApp line. Where does all of this fit in that we've been discussing, and access to the tribunal and to rulings there? If your deal has not been with a motorship dealer but with a private seller, or you've bought a vehicle described as footstoots, for example, from a private seller, do you have any legs to stand on?
Nope.
No, probably not. The Consumer Protection Act applies where the seller or the supplier is acting in the ordinary course of their business. So if Pippa, you or I sell our vehicle, it's not our business, right?
Yeah.
But if you buy from a private seller who is in the business of, on a regular basis, so buying and selling cars, then you can make out an argument that the CPA does apply and that the footstoots clause will not apply as a result, and you would still have the remedies that we described in the program. But here's potentially a reason to rather buy from a business if you are buying a second-hand vehicle than to buy from an individual, because you have less protection.
And just lastly, another area that I hear a lot from people about is auctions. You don't have any recourse there either. So that's
Yes.
not the best way to buy a car, unless you're in the game and you really know what you're doing.
Okay.
Well,
good to know.
you have to be such an expert. The problem is you often can't inspect the vehicles beforehand.
Can't drive them.
And the sorts of cars that are auctioned are often the ones that have been repossessed and have not been properly maintained. So no, as an individual, I would really strongly recommend that you stay away from auctions unless you're a complete expert.
Trudie Broekmann, it's always such a pleasure to have you on the show. Thank you for your time this afternoon. Cape Town-based consumer attorney. So having spoken about the theory of how things work and how cases end up at the National Consumer Tribunal, I thought it would be helpful to share an actual case study with you. And it's a very current case study because the ruling we're talking about literally only came in a couple of weeks ago. We have the complainant Sarah on the line with us from North Riding in Gauteng. And the background is this, that Sarah bought a vehicle from a Mercedes-Benz branch in Constantia Kloof back in 2017. And in May 2020, she first experienced a particular issue with the car. It lost power, a dashboard display light went on, warning that the electronic stability program was inoperative. And Sarah had to have the vehicle towed to the dealership, who she had been taking the car back to for regular servicing. And at the dealership, a diagnostic test was run, which indicated that the throttle valve actuator had malfunctioned. Do not ask me to explain what that is or what it does, but that is the part she was told is faulty and needs to be replaced. At some cost, it should be added, the job was done. Sarah paid more than 20,000 Rand for that repair. And then less than a week later, the same problem recurred. The car lost power, the same warning light came on again, and she had to take it back to the dealership again. And that is where the real fight began, because this time she was told it's the car's engine control unit that is damaged and needs replacing, and sorry, it's going to cost you another 27,000 Rand.
Because this car was out of warranty.
Because it was now out of warranty. Wendy, Sarah did not take that news well and was not prepared to simply accept what she was being told, that this was a totally unrelated, different repair. And sorry for you, it's just bad luck that they've both happened in the space of 1 week.
You see, it was the same fault that came up, and she wasn't told anything, that this could mean this or that or the other, or there could be this. We hope we've got it, but it could be something else. And literally, it was lockdown. She said she drove it home, didn't drive it the next day, and then the day after that, it was same problem. So it was pretty much immediate. Anyway, so she contacted, as Trudie described earlier, the processes. You've got to go to the Motor Industry Ombudsman. Found in her favour, recommended that the dealership repair the vehicle at its own cost, or that Sarah be put in the same financial position that she was in before the repairs were carried out on her car. The dealership said, no, we're not going to do that. We don't think the Ombud's right. And this is the problem, because they often do that. And that's when you're forced to go further.
Okay, so again, she got the ruling in her favour, but they said, well, we are not obliged to adhere to that ruling. We don't agree, so we're not going to do anything. She then did the next step, which was to approach the National Consumer Commission, as Trudie explained to us. They said, sorry, there's not enough evidence to prove this. At this point, let's bring Sarah in herself so that you can hear what happened next from the horse's mouth, as it were. Sarah, we so appreciate your joining us on the show today. Welcome.
Thank you, Wendy. Appreciate to be here.
Sarah, you were not prepared to back down, so you ended up pursuing this case all the way to the National Consumer Tribunal. How long did it actually take for you to get a hearing there?
Sure, the car went in May 2020. I only got the hearing now in May. That's how long it took.
So from May 2020
3 years
to 2023 is what you waited to finally see the case heard. And I believe, Sarah, that you represented yourself in the face of a dealership and its phalanx of lawyers. You fought your own case. It must have been a quite intimidating situation, I'd imagine.
Yeah, I must tell you, that was very intimidating. So it was done via Teams.
Yeah.
So when cameras went on, it was all male. I was the only female there. So, the panel from the tribunal was very friendly. And I saw, you looked at the Mercedes offices, very intimidating, white shirts, ties. You could see the representatives there, files on top of the table, a lot of files and paperwork. And I was like, oh, my goodness, how am I going to do this? But something inside me I stuck to my story. I knew the truth. I'm not going to fabricate anything. It was quite clear for me that I know what the issue is, and I was going to fight it.
Mm.
I love that.
I love that attitude.
I love that. So we should probably say that the dealership, towards the end of that hearing, did offer, or at some point, did offer to fix the car at their cost. at cost price. Sorry, not to make any profit on it, but you'd obviously have to pay something, and to waive almost 3 years of storage fees. Very magnanimous. You rejected that offer. What was your main argument that you put forward for not having to pay a second time for what appeared to be exactly the same fault that the car was showing up on its display?
Yeah, so at the hearing, a lot of the argument was around the technical part of the testing and the diagnostic. And I was told that the tests were correct. So my argument to them is no matter how advanced machines, together with the people who operate the machines, can make mistakes. I was clear on that. And secondly, Contract Law 101. We were had a contract. I give you my car, you will put it in a working condition, and I pay you $20,000. That's a lot of money for an individual.
Yeah.
So I paid that, and you give me a car with the same problem. Something inside me said, Sarah, you may not be an attorney, you may not be a motor mechanic, but you don't need to be one. This does not make sense.
Yeah. And the tribunal agreed with you, Sarah. You, on the 25th of April, got a ruling in your favor. Tell us what the outcome was.
So the outcome was I got, they needed to pay my money back, 80% of that. And I must be honest, I wasn't happy with that. I expected the full amount because I don't think I did anything wrong there. And they needed to release the car to me immediately. So I must be honest, I had mixed emotions. The other one part of me was very excited and happy that, you must always listen to your gut feeling, and you don't need, the important thing is talk to people, ask questions. There's knowledge out there, and that helped a lot.
Yeah.
The part that I wasn't happy with was the fact that even though I got the car, when I fetched it, there were a lot of things wrong. I was worried about that. One, the handbrake had broken. Two, the engine cover was not there. Three, I had to pay towing costs from Mercedes to my house. I had to buy a new battery. Over and above that, I found that they had changed a part of my car, a battery center. So when we wanted to fit in the new battery, it was confirmed that that battery center, the part number, does not correlate with my VIN number. So in the 2 years my car was sitting there, those things took place. And that's the worry I had. One, I paid for over 2 years. I paid for a car I didn't have. Yeah. And to get my car in that condition as well, that I was not happy with.
They admitted that there was a problem when they couldn't refute it because the VIN number told the story, and then they did replace it with the correct part, right? And you have that done, and the engine cover they've promised you, but is still on order, and you're not paying any extra. Okay.
Yes.
Okay.
So the center was replaced. I'm still waiting for the engine cover, and the handbrake was replaced as well.
Okay. Sarah, what about the money they owe you? Have they paid what the tribunal ordered them to pay?
Yes, they did pay the money.
That was my first question, because I've had cases where years later the money hasn't been paid. So
well, it's good to know that that at least has been done.
I did try and get an interview with the dealer principal, who incidentally wasn't the dealer principal at the time. I phoned yesterday, I phoned this morning, and hasn't called back.
Okay, but I'm glad to know, and thank you for acknowledging that. So the money has been paid, and they've said they're making good on the other things that went wrong in the interim. I mean, Sarah, just in closing, obviously, kudos to you for being prepared to tough it out and fight it all the way to the tribunal, and for sticking to your guns on what your gut told you was the right way forward. What do you hope other motorists can take away from your victory? I mean, what's the reason for sharing this with us today? What do you hope others will learn from what you went through?
So when the problem started, I went on hellopeter.com and I saw the number of complaints that were there. And I was wondering, how is this helping people? And for some reason inside me, I wished I could share this. And Wendy, when you approached me, though I was nervous and anxious, I want to say to people, ask for information. If your gut tells you, fight for it. Be patient. There's a lot of people who can help you out there, but don't leave it there and say, I've got the money, let me pay. It is not worth it. For me, if I go to a reputable dealer, you told me you're reputable. I didn't go to a mechanic somewhere in the corner, and to get this type of service for me was not right. So I want to say to people, I'm hoping they will learn from my story. And if there are people there who've got their cars out of warranty, it is worth fighting it. especially if you know you've got a case and you've got your facts right. Don't fight it because you can, but if you know you've got your facts right and you've done your part, understand the National Credit Act. That is critical.
Sarah, you've done your part and more. Thank you so much. You've done a great job of conveying how the
Thank you,
system
Sarah.
worked for you. We really appreciate it. I know you were nervous to join us, but you've done such a great job in summing it up for us today. And I hope that all those last remaining outstanding repairs are sorted out and you get back to enjoying being able to drive your car again.
I think the practical, the nature of these things, and we have it all on paper, but how it actually works and the little complexities and challenges along the way are important to share so people know what they're about. One thing we didn't canvass is that Sarah got her car repaired, because remember that it still wasn't repaired,
Yes.
at another Mercedes-Benz dealership, and it cost her, it was another fault, and it cost her 3,100 Rand, including
For what she
labour.
was told would be
Yeah,
27,000. Wow.
And she'd
Okay.
already paid 24.
Yeah. Okay. Thank you again, Sarah, and thank you, Wendy Knowler, as always. A reminder that if you want to bring a case to Wendy, the email address to use is consumer@knowler.co.za, spelled KNOWLER. Please remember to put the words Cape Talk in the subject line, and Wendy will chat again next week.
Lunch with Pippa Hudson
on Cape Talk.